All right, as I said earlier on, Devin Murugan is with us. And Devin, you want to find out exactly how the business rescue will actually unfold.
Yeah, I mean, it's something that was in the making for some time. We're finally at that date. In fact, it's day one. The national carrier is under business rescue. South African Airways, as a company, is subject to the Companies Act, which requires all businesses to be solvent and liquid. SAA met neither of the criteria. So what will change in the operations? Who's in control of SAA from today? Just how concerned should staff be, and indeed customers who fly SAA? Loius Klopper is a business practitioner who has been responsible for other companies which made headlines recently. He joins us from our Durban studio for more insight into this. Loius, thanks very much indeed for talking to us. Who's in control of this airline now as a company? Presumably not government.
Good morning. Thank you. Yes, indeed not government. The Act is very clear that when a company goes under business rescue, the business rescue practitioner takes control of the affairs of the company in substitution of the pre-existing board and management. That is very clear in the Act.
And presumably now the business practitioner is the one that decides on the way forward. I mean, only creditors, I understand it, will be able to vote in some of the decision making.
Well, creditors and affected parties. Affected parties, for example, the shareholder who has got a lot of loans into SAA. On the other hand, if there's any monies owing to staff for any reason, they become an affected party and are allowed to vote. However, the main objective of a business rescue practitioner is to investigate the affairs of the company and to report to the first meeting of creditors within 10 days after his or her appointment, and forward an opinion at that first creditors meeting on whether the company can be rescued or not. If it is the opinion of the business rescue practitioner that the company cannot be rescued, then the law is very clear. The practitioner then has no other choice but to file for liquidation. However, within 25 days after the appointment, the practitioner must then present a turnaround plan, or what we refer to as a business rescue plan, to the creditors to vote on. So you can see that 25 business days, 5 weeks, is a very, very short space of time. However, that can be extended with the blessing of the creditors to extend the period, which I expect is probably going to happen here.
So how many businesses of this magnitude go under business rescue and still survive? And in that regard, what is the likely outcome of SAA?
Well, the statistics from CIPC are not all that great. The problem really is that companies wait too long before they go under business rescue. If one is guided by the Act, in particular sections 4 and 22 of the Act, thereafter the Act says at first sign of financial distress, companies should file for business rescue. But companies dally too long with that decision, and by the time they get summonses or that it's way too late, they then rush to business rescue, and unfortunately, in most cases, it's too late.
Is it inevitable in this scenario that we would see job losses?
Well, you know, I cannot preempt what the practitioner is going to do in this case. However, if one looks at various statistics that have been floating around on social media, that it appears from those reports that SAA has got too many staff relative to the to the size of its fleet, then job losses are probably inevitable as one of the cost-cutting measures. However, I would not say that that is the only measure that can be employed by a practitioner, but it does appear that it is probably inevitable.
Loius, SAA telling us in a press statement this morning that Mango Airlines, its subsidiary, will operate normally, but not the same certainty coming around SAA itself. What can customers expect?
Yeah, I think that's $1 million question. You know, Mango is not the only airline operated by SAA. You've got Airlink and the others as well, but you've got the SAA foreign operations. You've got the whole technical service and all that. So it's really a very complex operation, and a practitioner is going to have to get his mind around the quantum of the operations very, very quickly to be able to determine where the intervention is most needed.
I would think that, you know, with such a colossal process, there was also this issue of contracts that were previously signed into. A practitioner, I would imagine, may have to renegotiate those contracts to the benefit of all parties. Presumably this would include wage agreements and, as we spoke about before, could even include retrenchments.
Yes, the Act does allow a practitioner to intervene with any contracts that are found not to be to the benefit of the company, because bearing in mind, business rescue is so designed that it should produce a better outcome for creditors other than the company immediately going into liquidation. So I think any practitioner is going to have his work cut out here to decide how quickly and where are the interventions required so that the company can come out fitter, leaner and stronger on the other side, as is compared to the case at the moment.
We're going to have to leave it there. Loius Klopper is a business practitioner there, talking to us about the possible fate of South African Airways under business rescue, Tony.
All right, I think colossal is a good word you picked there. It's a colossal task indeed. Devin Morgan, thank you so much.